Good morning, everyone. Thank you so much for joining us today for a Disability Basics webinar. My name is Natasha Dunker. I'm Communications Director for PERAC. I'll be in the background helping out while the webinar takes place. For just some housekeeping things, this webinar will earn retirement board members 3 educational credits. You'll see your credits in your Prosper account in approximately 1 week. We are recording the webinar, so we will post it to the website in a few weeks. And finally, I'm going to drop the link to the handout into the chat. If you haven't downloaded it already, you can do so from the chat. And questions, you can put them into the Q&A as you think of them, and we will take all questions at the end because we have a lot to cover today. And with that, I'm going to hand it off to our Executive Director, Bill Keefe. Thank you.
Thank you, Natasha. Good morning, everybody. Thank you for joining us today. We just heard from Natasha before we came on that we have a crowd of about 283. I was just checking StubHub. I think the ticket prices are rivaling those of the Bruins, so who knew the PERAC was such a hot ticket? This is my first time as Executive Director welcoming you, and I want to thank you all for the work that you do. Thank you for your interest in participating in this education today. I know some of you I haven't got to meet yet, and certainly want to get out there more and do that. We'll be making some board visits and continue to be at Macris to have those informal conversations where all the good stuff happens. Quick just reminder, we have some board members still needing to file SFIs. The vast majority have. So if either you're a member on here, if you're staff, just if you have any of your people that haven't filed that yet, please remind them to do so. We have a few boards left with annual statements, and some have asked for extensions, but just putting those reminders out there. Where everybody here is preparing for Macris. We hope to see a number of you there. A number of PERAC people are preparing to present and also be there in attendance. Ken and Patrick will be presenting on Chapter 32 in a nutshell. Patrick Charles, Felicia McGinnis will be presenting on post-retirement work. John Borak and Scott Henderson will be doing disability calculation basics. That should be a nice breathable Merlot that should pair nicely with today's session. I don't know what I'm talking about. I don't know anything about wine. Just going off the pairing thing. Patrick Charles will be presenting as part of the legislative panel. Judith Corrigan will be part of the legal panel, and then Judith will also be presenting on popular pension misconceptions. And as I said, we'll all be around from Saturday through Wednesday for conversations and questions. So Patrice and Ken today are switching hats today after running our first ever chili cook-off yesterday at PERAC. We made that part of a monthly staff meeting. It was a lot of fun. I went from tasting chili for lunch, and last night I was proud to attend my daughter's nursing pinning ceremony. And so after that, as a family, we went out for Chinese food. So I went from eating chili to Chinese food, might have had a couple Mai Tais, and now I have a physical this afternoon. So I'm really looking forward to see what the blood numbers come back as. Should be fantastic. But anyway, with that, I'm going to turn it over to Ken. First, Patrice is going to cover the process. Ken is going to discuss why we do remands, but I'm going to turn it over to Ken right now. Enjoy the session.
Thanks, Bill. I just have just a minute here. We'd received a lot of feedback that staff and board members wanted some information, more information on disabilities. We had originally hoped, excuse me, to do a presentation that goes along with a user guide that we've been developing, a user guide for Prosper in the disability applications of it. Unfortunately, as we started to go through it, we realized that a slide presentation like this is really not the best venue for something like that. We really need to do something where it's in-house, we're all together, everyone has their laptops and logged into Prosper, and we can go along. So we're going to be trying to arrange something like that in the not too distant future. I think that would be very helpful. We did a trial run with one board already, and we've got really good feedback, and we all thought it went well. So that will be coming up. What might hamper things a little bit is we'll be leaving this office in the not too distant future, and we keep losing furniture. So I'm not sure if we have enough tables right now, but we'll figure something out. Speaking of the furniture, though, because we're moving, we are getting rid of a lot of furniture. We have a lot of workstations, file cabinets, shelving units, you name it, we have a lot of it. If any boards out there are interested in any of this free furniture, please contact Caroline Karship. Okay, she got very excited when I just spoke to her on the phone and asked if it was okay if I throw that out there. Very excited. So just give her a call. But with that, I would like to throw it to Patrice Luby, the Manager of Medical Services at PERAC.
Thank you, Ken. Good morning, everybody. I'm Patrice Luby, Manager of Medical Services, as Ken has just mentioned. Today's presentation will cover accidental disability retirement medical panels and disability remands. Next slide. I'll be focusing on the medical panel process, and Ken Hill will be focusing on the reasons for remands and accidental retirements. Next slide. So we hope that our presentation today covers everything that you want to know about these topics, but if we miss something, jot down your questions and we'll be happy to address them after the presentations have been completed, as Natasha has noted. Today, I'm briefly going to review the types of disability retirement. The first is ordinary disability, which is a generally disabling condition which has no relationship to the applicant's duty. The second is accidental disability, which is a permanently disabling condition which was caused by the specific injury or hazard undergone caused by the nature of the applicant's employment. Next slide. PERAC's processes and procedures are mandated by Chapter 32 in Disability Regulations 840 CMR Section 10 and were formulated to ensure a fair and equitable process. So today I'll be discussing Sections 6 and 7. We hope that you will see us as a resource at PERAC to assist you in navigating through these processes. Now, any of you that have processed a disability retirement application know that there's a lot of information to cover. So in order to cover everything, we'll go over the important factors and the common questions that usually arise during the process. The medical panel unit at PERAC's role is to determine, based on the information provided, that the medical panel can be convened, appoint the appropriate physicians to examine the applicant, and to provide a usable medical report for the retirement board. Next slide. So let's talk about the different types of retirement. The first one would be superannuation, which is Section 5. And that is a benefit that's determined by age, years of service, salary, and group classification. Accidental, which is Section 7, is a benefit that is 72% of your salary with no service requirement. Ordinary, which is a Section 6, is a benefit that is determined by age and salary with a minimum of 10 years and sometimes 15 of service and a veteran's factor. The common question we are asked is, can and should somebody apply for more than one? And this answer varies between individuals, but generally, yes. The reason for this is approval for one does not preclude the others. The application for disability retirement is a pretty lengthy process. Next slide. So does the decision to seek disability impact retirement? And the answer is yes. Unlike superannuation, there are post-retirement requirements associated with both the ordinary and the accidental disability retirement. People need to be aware of these requirements as it may impact their decision. Next slide. So what are the post-disability requirements? While receiving a disability retirement, the retiree is required to submit 91A earnings statements yearly per Section 91A of Chapter 32 and provide updated medical information and undergo exams per Section 8 of Chapter 32. Many people say to us, I didn't know there were any earning limits. Well, the panel told me that my disability is permanent. Why do I have to keep sending medical information? Both of these requirements are an important factor for retirees, and they need to be aware of them. So while I as we all suspect that the applicant forgets that they were told about these requirements at the board level, some of the most common questions we receive at PERAC are these specific questions. Next slide. So what are the eligibility requirements for disability retirement? So what's the difference between the accidental and the ordinary? So the ordinary in section 6, generally this is a fairly catastrophic medical condition that prevents an employee from performing their job without a connection to their employment. The accidental, which is the section 7, is a medical condition that prevents an employee from performing the essential duties of their job with a causal connection. That means it's an accident that occurs while they were working. Again, the ordinary, there is a 10-year requirement, and for the accidental, there are no minimal service requirements. Next slide. So how does somebody apply for disability retirement? The first step is a member of a retirement system needs to contact the retirement board. The retirement board is going to counsel the member and provide him or her with an application for them to complete. The board will then submit a treating physician statement to the applicant's doctor, submit an employer's statement to the employer, and collect medical records. Now, this is generally the longest part of the process. The applicant should be informed that the entire process will take months to complete, and they need to plan for that. As I've discussed earlier, this may be a situation where the applicant would apply for superannuation if they don't have enough sick time to provide income while this is in process. Next slide. So what does the application contain? It contains a member's application, which includes employment history and medical release forms, the treating physician statement, which supports the application and must answer all 3 questions of incapacity, permanency, and if it's an accidental, causation. The application also includes an employer statement, which includes the job description and injury reports, and the last 5 years of the member's medical records. So PERAC requires that the above documents be available prior to convening a medical panel and making a final submission to PERAC through Prosper, which is PERAC's electronic portal. Now, I can't stress enough that the major reasons for the delays in the process is that some portion of the above information is not available to the panel when they examine the applicant. This can cause delays in scheduling, as well as cancellations of the medical panel appointments. So the screen you're looking at right now are the required forms for each type of disability requirement application. I'm not going to go through this right now, but this is a pretty good resource for you, especially when you're starting to learn how to process these applications. Next slide. So what are the medical panel requirements for disability retirement? Both the treating physician and a majority of a 3-member panel must find that the applicant is mentally or physically incapable of performing the essential duties of their position, and that the incapacity is likely to be permanent. In the case of the application for accidental, the physicians must also find yes to question number 3, which is the said capacity such as might be the natural and proximate result of the personal injury sustained or hazard undergone on account of which retirement is claimed. So in order to appoint a panel for an accidental, we require this documentation first. If this part of the application is not completed, you'll be being contacted by the disability unit. Just a thought on permanency. Permanency is not what you may think. You may consider permanency to be a lifelong condition, which is generally the accepted meaning. However, the standard for permanency as it applies to disability retirement is it cannot be determined when it will end. This is very different from the lifelong meaning and the reason for many questions from retirees about this. So now that we've discussed service and medical requirements, next slide, What about the involuntary application, which is a section 16? What are the differences and the similarities? When the member or applicant files an application for disability, we refer to this as a voluntary application. An employee files the application and provides the necessary medical records, etc. In the case of an involuntary application, the employer files the application. There's no treating physician statement, and the employee is not required to supply any medical records. So then we ask the board to provide us with a medical summary from the record so that we can make a specialty determination. PERAC handles the medical panel process the same way as if the application was for a voluntary. Now, the impact of the involuntary is that the panel physicians will only have what is available to the employer, such as workers' comp records or 111F medical exams, etc. So because of the possibility of an incomplete medical record, there can be delays with these applications. Either the physicians don't have the information they need when they try to request it, or they cannot make a clear determination because they don't have all the information they need. Next slide. And so what about the presumptions? The presumptions are as follows. The section 94 is the heart presumption, 94A is the lung presumption, and 94B is the cancer presumption. The presumptions are available to police, firefighters, corrections officers, and some others. The heart presumption is available to all three, but the lung and cancer are available only to firefighters. The presumption is that the disabling condition is presumed to be caused by the job. The applicant still must be determined to be disabled while a member in service, and the condition still must be considered permanent. Now, the cancer presumption has a 5-year window of discovery after the last date of service, but that's only the cancer presumption. So now that we've discussed types of retirement and eligibility requirements, let's discuss the medical records. Next slide. So once a member applies, the retirement board is collecting a lot of information: the application, the employer statement, job description, and medical records from the applicant's doctors, facilities, and therapy treatments. So what does the board need to do with all of this? It all has to be compiled and it has to be organized. Next slide. So now that we have Prosper, the board is only required to maintain one copy at the board level and submit the medical records through Prosper, which is our electronic portal. Now, the physicians rely on these medical records in order to make their medical determinations. The medical records that the board is requesting is for the last 5 years from the member. As non-medical people, handling this information is important to note that you have to maintain confidentiality and the documents need to be stored in a secure area. So now we need to organize these for review. Next slide. Again, I can't stress enough how important this is. If the medical records are not available, appointments do get canceled. If they're not organized, physicians may not be able to identify important documents. So it's a very cumbersome job, but it's a very important one. From the time the member's application onward, the medical record is going to be reviewed by many people: the retirement board, attorneys, medical panel physicians, nurse case managers, and post-retirement physicians. Having the medical records organized is a very important component of this application. So the medical records are submitted to PERAC electronically at the time of requesting a medical panel via our electronic portal Prosper. Next slide. So based on the information before them, the retirement board at this point can either deny the application or they can request a medical panel. We're going to assume that the board is approving this application to be sent to PERAC for a medical panel. Next slide. So based on the provision of all the material collected, a 3-member medical panel will be appointed by PERAC. We are looking at the information that the boards provide to make sure that the minimal eligibility requirements are met, that the physician's statement answers the necessary questions, and to determine the type of panel that should be appointed. Next slide. So who are the medical panel physicians? They are board certified or board eligible MDs. They're not financially associated. They are independent medical examiners, and they're specialists in the applicant's condition. So why does it take so long for some medical panels? Next slide. The applicants have the option of either a joint, which is 3 doctors at one time, or separate medical panels. At times, we may run into difficulty trying to get 3 doctors with the correct specialties to one location at the same time and the same date. This factor may affect the time frame from the actual request to the panel appointment. Western Mass and Springfield, the areas are particularly problematic. Even though an applicant may request a joint panel based on their location or condition, this is not always possible, and 3 separate exams may need to be scheduled. So who can attend a medical panel? Since the principal purpose of the examination is to discuss and evaluate the physical condition or mental health of the member, attendance at the examination shall be limited to the member and the medical panel physicians, the employee's physician and the employer's physician. The member's attorney and the employer's attorney may attend the examination. The member may permit the presence of other individuals, provided that their presence will not disrupt the examination. Next slide. So just some notes on notification, rescheduling, and no-shows. The PERAC does provide at least a 14-day notice to the members for their exams. If the members do not show up for their exams, they will be assessed a no-show payment of $150 for a single appointment and $375 for a joint panel. And there are times that we will waive for limited circumstances for an applicant illness, weather-related conditions, but we do not reschedule for attorneys or others to attend. Next slide. So now the exam has taken place. When we do receive the medical panel reports, there are 2 PERAC reviewers for each medical panel report that we receive. We review for completeness. We are looking for an independent medical opinion. We do not review for how they are finding either yes or no. We are reviewing the reports to ensure that the doctors are following our format and that they answer and support their findings to the 3 questions. A survey is also sent for every appointment scheduled. If we receive a complaint or a negative survey about an exam, it's followed up on by the disability unit staff. If a board has questions about a report, or if they have received differing opinions, they can request what is called a clarification. A clarification can be found in 840 CMR, Section 10. As far as the procedure, the board sends a request to PERAC via Prosper, and we'll forward it to the board, to the panel physicians. After the first clarification request, PERAC will review subsequent requests. Next slide. So PERAC will then forward the report to the retirement board. Based on the complete application, along with the medical panel reports, the board is now going to make a decision to either approve or deny the application. So at this point, that completes the medical panel process of the application, and hopefully I covered everything that you wanted to know about the application and the medical panel process. And now Ken Hill, who is PERAC's Deputy Director, will speak to you about disability retirement remands.
Thank you, Patrice. I will just say that the disability unit is very well staffed with very knowledgeable people who've been here a good amount of time. I'll just put it that way. They're always available to help and to answer any questions. So please do not hesitate to use them as a resource. And with that, I'll get to my presentation. Board, as you know, boards have the ability to approve or deny disability applications. Now, if there is a negative medical panel, okay, meaning that the majority of the doctors, 2 out of 3 being the majority, if they find that the person is either not incapacitated, that the injury is not permanent, or that it was not caused by the job, then the board cannot approve an accidental disability, okay? Automatically cannot do it. If there is a positive majority panel, the board may approve the application. They do not have to. If the board has questions or issues with anything that the medical panel said or did, they may seek clarification from the medical panel, or they may petition PERAC for a new panel or a new panelist. Now, if the board approves the application, it goes to PERAC for review. Okay. At this point, my presentation is assuming that the board has approved the application. Okay, and then it comes to us. No, before I forget too, Patrice does a great job with her slides. You know, the pictures and the graphs and every great job. If you like those kind of slides, you're probably going to hate my presentation because it's just words. I apologize, but that's just my style. I have no style. Thank you. Next slide. Now, PERAC's authority to review the board's grants of disability applications can be found in section 21D of chapter 32. PERAC has 30 days to either approve or remand the approval back to the board. If PERAC, for some reason, fails to act in either way, it is deemed automatically approved. Okay, so we take that 30-day deadline very seriously. Okay. Now, section 21(1)D contains 4 categories or reasons why PERAC may remand the approval of an application. The first being if something was done under unlawful procedure. This is rarely done. I'll discuss it shortly, but that's rarely a reason why we have to remand. The second reason is if it is unsupported by substantial evidence. This is by far the most common reason why we have to remand an application. The third reason is if it is arbitrary or capricious. I've never seen this. We've never remanded for that reason. And the final is if there is fraud or misrepresentation. I could see us remanding for that reason, but I can't recall it. So the first 2 are really the only 2 that we ever utilize. Now, the first one being unlawful procedure. Okay, it sounds very harsh. You know, it sounds like you know, the board broke the law. That's not it. In reality, it usually just means that the board failed to follow a procedural requirement. And the following slides are going to address some kind of those failures that we see. The first being something I already mentioned. If there's a lack of a positive medical panel, meaning if, you know, 2 out of 3 doctors do not find for either incapacity, permanence, or causation, then it cannot be granted. Sometimes we see boards that say things like, but the medical panel is wrong. Unfortunately, the board has no authority to substitute its judgment for that of the medical panel. They cannot just approve it. They can seek clarification, they can seek a new panelist, things like that, but they cannot just overrule what the medical panel has decided. Except there is that exception. In the case of the presumptions, the board may overrule the causation finding of a doctor. Okay. Another reason why we may have to remand for unlawful procedure is if it is, the application is missing documents. Section 6 and 7 and 16 for involuntary applications, as well as PERAC regulations, list documents that must be included in an application. Patrice had a great chart in her presentation that goes through, and if a person applies for a certain kind of disability retirement, what documents are needed. I recommend everyone, you know, print that up and put it right next to their computer at work. It'll come in very handy. Some of those documents being the treating physician statement, a job description, the employer statement, pre-employment physical examinations for presumption cases, things like that. Now, when PERAC receives an approval and we note that any of these documents are missing, we do not remand it right away. No, we immediately reach out to the board and we say, you know, what you've sent us does not include this document. We need it. And then we wait and hope that the board can find it. Most often the board is able to find those missing documents and get it to us. And only when we get up to that 30-day deadline do we remand it back to the board. Another unlawful procedure is if the board fails to file via Prosper. Okay, Prosper being you know, the platform that we use for so many applications nowadays. It launched for disabilities in 2017. You know, obviously we're 7 years in. I think this might be the last time that I use this slide because we don't see it anymore. Everyone has become accustomed to using Prosper and it works tremendously. And again, everyone's familiar. So this say goodbye to this slide. Another unlawful procedure situation that we see involves ordinary disabilities. As Patrice said, most boards require that for an ordinary, excuse me, the member must have worked at least 10 years of credible service. Three boards do require 15 years. For veterans, even if they were part of one of those three boards, they only need 10 years. Sometimes we see applications that come in and it's, you know, it says that the member started working in 2016 and we're reviewing it in 2024 and we're like, are there 10 years somehow in here? So we reach out to the board. Oftentimes there's some sort of military buyback that gets the person credible service to get over the 10 years. But we just need to see that documented so we know, and so we don't have to remand it. The best practice is to include a breakdown of the creditable service with an ordinary application, just so we know and we don't have to, you know, go through the process. For involuntary applications, okay, these are done via section 16, okay? It happens when the employer fails to include a statement of facts with an application for involuntary. It specifically states in the 16(1)(a), there's a quote up here, that it must include a fair summary of the facts. Now, this is a fair summary of the facts is different from the employer's statement that also must accompany it. It doesn't have to be a tremendous document, but it does need, I mean, it's a very important moment when someone gets involuntarily retired, okay? That usually means they don't want to be retired. So the fair summary is a requirement and we do enforce it. And, you know, most employers, they're looking to backfill the position. So they do accommodate the statute, not us, accommodate the statute. Recently, we've had a couple of involuntary applications where we've had to remand. One such situation involves a scenario where the employer filed for the involuntary accidental disability retirement for an employee, except the employee was no longer an employee. The employer had terminated the employee about 1 month prior to filing the involuntary application. The employer lacked the standing to file such an application because there was no employee. So we did have to remand it. I mean, if you look at the statute itself, it says that any member employed therein. Well, this person was no longer employed therein. So we had to remand that. Next slide, please. Another situation that we recently had where an employer filed an involuntary accidental disability application for a firefighter/EMT. They did include a fair summary of the facts, but it merely stated that firefighter/EMT had PTSD and was seeking treatment. There was no summary of the facts giving rise to those conclusions. And the fair summary, it needs to spell out the who, what, where, when. And obviously just saying someone had PTSD and was seeking treatment was not sufficient under the statute. So before I get to this one, I meant to mention it earlier and I apologize. Oftentimes when we remand, our remand letters tell the board what's needed, how to get it, and how they can basically save this application. And more often than not, the board is able to do that. And I mean, the situations that I'm going to read, once we've remanded, many of these people eventually got their disability retirement because the board was able to make findings of fact. And, you know, or get a statement of facts from the employer, you know, do what needs to be done. So I don't want you to think that once we remanded, it's over, because that's far from the truth. Now, the second category for reasons that we have to remand is if the application is unsupported by substantial evidence. As I told you, this is the overwhelming majority of reasons why we have to remand. Again, the board is the finder of fact. So the more facts that the board can put in, the more support and evidence they have for the application. So we encourage boards to make findings of fact. Okay? Now, the following slides detail some general categories we encounter that fall under this unsupported by substantial evidence umbrella. Okay. The next slide, please. Section 7, which is accidental disability, requires that the applicant must be injured, quote, as a result of and while in the performance of his or her job duties. Now, there are several subcategories that fall under this that we encounter. An applicant is not entitled to an accidental disability if they're injured while engaged in any of the following examples. If they sustain an injury while going to, from, or at lunch or on a break. If they're injured while going to, from, or in the bathroom. If they're injured on the way to begin work or after leaving work. If they're injured due to coworker horseplay, or if they're injured while performing a duty that's outside of their job description, or that they're not performing an actual job duty when they're injured. And we'll go through those. Okay, the first one involves going to, from, or at lunch or on a break. In 1959, the Supreme Judicial Court decided two similar cases on the same day. In one case, a nurse was injured when she left work to go home for lunch. The second case, a stadium matron, I don't know what that is, was injured while on her way back to work following lunch. The SJC determined that eligibility hinges on whether the applicant was going from a work-related obligation to a work-related obligation. In both of these cases, the SJC found that neither was eligible for accidental disability retirement because one was injured while walking to a non-work obligation, lunch, and the other was walking from a non-work obligation, lunch. If you take anything at all from this presentation, take the fact that if you're injured while walking someplace, you need to be going from a work obligation to a work obligation. And as the SJC even noted at that time in 1959, that this was a harsh standard. It has been, you know, the Namvar case in 1996 even noted this is harsh, but it's been the law since 1959. And it's strict, and it's told the legislature, if this needs a, you know, if we're going to fix this, the legislature needs to fix it. And there has not been a fix. So we need to apply this uniformly. And again, everyone will say this is a harsh result, but to be eligible, you need to be going from a work obligation to a work obligation. Next slide, please. Okay, we see several of these, and they're very fact specific and they're very difficult. One that we saw recently, an applicant suffered a heart attack while he was eating lunch at home during his shift. As he was having the heart attack, he realized what was happening and he hopped in his cruiser and he drove to the police station. This poor gentleman was not eligible. He sustained his injury while at lunch, which is a non-work obligation, okay? And his attempt to drive to work did not help his eligibility because he was coming from lunch, which is a non-work obligation. Now, this matter had presumption issues for unrelated matters. They needed to apply for the Section 7, if anyone was wondering. Another one we saw that an applicant had a stroke while he was off duty and at home. He claimed that he was responding to an alarm call, but even if that were true, he was at his home, which was a non-work obligation, so he was not eligible. No, could you go back one? I'm sorry. I didn't write this one down because this one is currently under appeal. If the board denies an application following a PERAC remand, they can appeal it to an administrative body called the Division of Administrative Law Appeals, or DALA, we commonly call it. Then if they don't like, if one of the parties does not like that decision, they can then appeal it to what's called the Contributory Retirement Appeal Board, or CRAB. This one, the next one I'm going to talk about, is currently under appeal to CRAB, okay? But the fact pattern of this one, it's very fact specific. There was a member, she had to attend an offsite meeting with several other, colleagues from different, similar agencies, but different offices. They went to their meeting, then they went offsite from there to have lunch together. The evidence suggested that they ate lunch and then they sat there for another 15 minutes and continued to discuss work, things that had been discussed at the meeting. They then left the lunch, and the evidence showed that they were in the parking lot for about 15 minutes, continuing to discuss work. This member then got in her car and drove to her office. Unfortunately, on the way there, she was involved in a serious car accident and sustained injuries. An application was filed for accidental disability, and it was remanded because she was coming from lunch, which is a non-work obligation. She appealed it to DALA, and the magistrate found that the discussions that this member had with her colleagues while at lunch after eating and in the parking lot were continuations of the meeting that they were all at, and therefore was a work obligation. So the DALA magistrate found that she was at a work obligation, going to a work obligation, and she was eligible for the benefit. The board that's involved in this has appealed to the next step to the Contributory Retirement Appeal Board, but it will be very interesting to see how they rule in this matter. Again, that's why I didn't want to put it on the slide, because I don't know which way it's going to go, but that is a similar one we've dealt with recently. Okay, there is a long line of bathroom cases, people being, going from, or while they're in the bathroom, sustaining injuries. Going to the bathroom or being in the bathroom is not considered a work obligation. It's considered a biological obligation, but not a work obligation. This strict standard applies for bathrooms. You need to be going from a work obligation to a work obligation. Here are several cases where it's been found that it's not enough. The Doucette case, oh no, excuse me. I can't recall which case it was, but the one case, a woman argued that, she was in her stall and she was reprimanding the woman in the stall next to her, and then she injured herself going to the sink. Unfortunately, that was not found to be a work obligation in that scenario. Again, harsh results all around with the bathroom and the going to and going from standard. Recently, we've had some bathroom cases. In the first situation, no, next slide, please. A member was injured while leaving the bathroom and slipping on a recently washed floor. Now, the injury report said just that, really. But then when he had a hearing before his board, he testified that he was responding to a colleague's call for help, and so he had to rush and race his way that way. There was some witness statements. No one mentioned that. His injury report didn't mention that. And the board made findings of fact that, he was just coming from the bathroom and he was not eligible. The second member, second example, is a member who was injured when he slipped while in the bathroom / locker room at work. We originally remanded it, but then the board made findings of fact that actually that bathroom also contained a closet that contained blueprints, and that the member was actually going to get the blueprints. He was some sort of architect going to get the blueprints to do work. So that was found to be, he was going from his desk, which was a work obligation, to get the blueprints, which was a work obligation. So he was found eligible for accidental disability. Injured while traveling to or from work. The strict standard applies. You can't be at a non-work obligation, home, or you can't be going to a non-work obligation, home, and be eligible for it. Now, oftentimes it's ambiguous whether the member had actually started work or had actually finished work. As the board is the finder of fact, it's very important for the boards to investigate and attempt to clarify any ambiguity that may exist. We have many, many cases that deal with these scenarios. Next slide, please. We had one recently where a member was injured in her work facility, but it was before she arrived at her station to begin her work shift. So she had not started work yet. She was still in her commute aspect of work. Very harsh result. I believe that the board was able to make findings of fact after the fact and save that one. We get several, someone who's injured walking to their car in the parking lot after their shift ended. Harsh result. The law is set though, like that once you stop working, you're commuting and you're not eligible for accidental disability retirement. Again, someone injured after leaving work. We see people injured when they slipped in the parking lot. We live in New England. There's ice all over the place. If you haven't started your shift, you're still commuting. You're not eligible. These are the ones that are tough. The next one, injured while driving to a training site to start her day. Now, the argument is, I was only on that route because I had to go to this training, okay? Harsh result. Again, you're leaving your home, and the home is a non-work obligation. Injured in parking lot on the way to work, and injured while driving to work, that's commuting. The fact that you were, required to drive or you were in a state vehicle has been found not to usurp the work obligation requirement. We had one recently that, it was a police officer who arrived at the parking lot, got out of his car, slipped, fell, injured his back. The chief of police argued that, he was in uniform, he's considered to be on duty, and that he would have acted had an emergency arose, and he's responsible for, reacting if an emergency arose. All true. However, it does not overrule the work obligation argument. Case law is set that is the law, even with the facts that, that chief argued. I don't deny the truth in any of that, but the law is set, and unfortunately, he was found not to be eligible. We recently had a case, going back to, that training aspect, going to an offsite place. We recently had a case where, there was a member, and she and a few colleagues had to go to an offsite. But they decided, you know what, let's carpool together. So they all drove from their homes and they went to a parking lot of a supermarket. And they met up and they all, the four of them piled into one car. Um, you know, facts seem to show that, she may have been talking to the driver during it. Maybe they talked about work. It wasn't really clear. The two in the back, it seemed like, dozed off. Unfortunately, they got into a car accident. And the member was injured seriously and applied for accidental disability. We had to remand it because, she was coming from her home, a non-work obligation. She argued that we all met and that's where it should start. And, we were talking about work. Unfortunately, she ended up appealing it to DALA, and the magistrate found that, she didn't have a work obligation at home or at the carpool meeting site, and denied the application. The magistrate found that, she did this voluntarily and for convenience, and it wasn't a work obligation. That is a final decision of DALA. It was not appealed any further. But you can see how the facts seem to matter so much, and why I'm so interested in that case I mentioned earlier that is on appeal up to CRAB. We'll see what happens with that. It could be interesting. Maybe next time, if I have to do this presentation, I'll be able to update. Thank you. Okay, next slide, please. All right, that's enough of the on your way to or from non-work obligation, work obligation cases. The next are, you must be in the actual performance of your duties. The member must be performing an actual job duty at the time of injury. And they must be on duty when they sustain that injury. And there must be a nexus between the injury and the actual performance of his or her job. Now, one subcategory under this, next slide, please, is what has come to be known as coworker horseplay. The seminal case in this is the Damiano case. Poor Miss Damiano was a dispatcher. One day at work, one of her colleagues thought it would be funny to get her in a headlock and, kind of fake wrestle with her. Unfortunately, she fell backwards, hit her head, sustained back injury. She sustained injuries and, claimed that she was permanently incapacitated and applied for accidental disability. It went all the way up to the appeals court, okay? And the appeals court said that she was not eligible for accidental disability because the injury must be sustained in the line of duty. That is, during the actual performance of the duties that the employee has undertaken to perform on behalf of the public. She was not performing her duties as a dispatcher at the time she sustained this injury. So her injury was not sustained while she was in the line of duty. The Damiano case gets cited to on seemingly a daily basis in every court case that comes up. So she, unfortunately for her, will live in infamy through no fault of her own. Just a coworker who thought it would be funny to get her in a headlock. Recently, we've had a couple that were similar. One happened to be another dispatcher. He sustained an injury while attempting to perform a somersault. Now, this was a little strange. This was a strange case. His application said that he injured his head falling out of a chair. Okay. But there were other documents, there were witness statements and, a second injury report, I believe, that stated that he had attempted to jump off some sort of bouncy chair and do a backflip, but that he landed on his head and he really hurt himself. No doubt about that. We had to remand it because it didn't appear that he was injured while in the line of duty and while in the performance of his duties. And the board agreed and had to deny his application. The second one was a laborer who sustained an injury while throwing and catching a football with a colleague. He was, on a break, they were taking a little moment and he admitted, yeah, I tweaked it and I can't work anymore. Well, sorry, His job was like to literally to like go trim tree branches and you know, do things like that, mow, you know, lawns. It wasn't to play football. So although the board approved the application, we had to remand it, and you know, the board eventually agreed that he was not eligible. Okay, similar classic cases are when you're injured while you're not performing an actual job duty. To be eligible for accidental disability, you must be injured while performing an actual job duty. And this is one of the reasons why a job description must accompany an application. Okay. As I've stated, Section 7 requires that the injury be sustained as a result of and while in the performance of one's duties. Okay. The appeals court has determined that the duties part should be narrowly construed, and that there is a distinction drawn between actual performance of work and something incidental to such work. Now, the seminal case on this is the Connolly case. It's a situation where Mr. Connolly, he worked in an office like most of us do. He sustained a back injury while lifting and replacing the 5-gallon jug of Poland spring water in the water cooler. The appeals court determined that that was not one of his job duties, and the injury was not sustained. So the injury was not sustained while he was in the performance of his duties. This is a very harsh result in my mind. We have one of those water coolers here. I feel like I change that thing at least 3 times a week. I think about the Connolly case every time I change that water bottle, okay? Lift with my legs, not with my back, okay? I think everyone agrees that this is a very harsh case, the Connolly case. Often now we see, not a way to get around it, I don't mean it that way, but to make someone eligible in a scenario like this, job descriptions can sometimes say things like, you know, your job duties are also to do anything else to assist your employer or your colleagues. Something, a catch-all like that might work. Unfortunately, Mr. Connolly, apparently his job description didn't say anything like that. And the poor guy, he was just trying to help out his colleagues. All right, I need to move on. I really don't like that case. Next slide, please. We've had a few recently that we've had to remand that are somewhat similar to poor Mr. Connolly. The first one, there was an engineer, worked at a desk, you know, just supposed to engineer things. He sustained an injury because he was moving a file cabinet. That was not one of his job descriptions, okay? Another one, we had a mental health counselor who injured himself while attempting to move a dumpster with colleagues. Clearly, like moving a dumpster was not one of his job responsibilities. We had another one, a security guard sustained injuries while helping someone move boxes. The injury report even said he was not performing a job duty. He was just trying to be helpful. And that's what stinks here. Every one of these 3 people were just trying to be helpful. You know, they were trying to be Mr. Connolly, changing the water bottle. Unfortunately, you know, if it's not your job duty and you're injured while doing it, you're technically not eligible for accidental disability retirement. Now, recently, we had another case come up where someone was found not to be eligible, and it's the saddest case, sadder than the 4 I've just mentioned. It was someone working from home during COVID. Her doorbell rang. She went to answer the door. A disgruntled former neighbor was at the door and killed her. You know, her widowed husband applied for accidental death benefits, which is a similar standard, but under Section 9. And it went up to, you know, on remand to DALA, and the magistrate, you could tell the magistrate felt terrible, but her death was found not to be the result of or while she was in the performance of her duties. There was no nexus between her job and what happened. It was a personal matter, but it's a blurry line, and it's just incredibly sad. But that was a case, like I said, that was recently decided. And I believe I did not I did not put it up on the slide, and I won't mention the name here because I do not know if it has been appealed further. I do not think it has, but I wasn't sure. So I'm just going to move on from there. Sorry. Another reason where we have to remand if there is no injury report. Okay. An injury report is a requirement of an application for disability retirement unless the injury was sustained within 2 years of the application. Okay. And the injury report must be filed within 90 days of the injury. Okay. Or if not, if there's proof of receipt of workers' comp payments because of that same injury, or for members who are not members of Group 1, they can satisfy the written notice requirement if there's a record of such injury or hazard undergone on file in the official records of the department. What most often that means, it's for Group 4 members if there's an incident report rather than an injury report. They would be covered under this provision. Sometimes we see applications that claim they contain an injury report, but it's not really an injury report. Examples are affidavits recounting events of long ago that were written today or more than 90 days after the event. As I said, by statute, it has to be within 90 days of the alleged injury. Sometimes we see workers' compensation settlement documents. That's a legal, just agreement. That's not, that's not sufficient under the statute. Okay. Newspaper articles, some things make the news, absolutely, but they do not constitute an injury report for the purposes of Chapter 32. And sometimes we just see pieces of paper, no letterhead, no indication of where it came from or when it came from, just saying I injured my ex on X date. That's not sufficient, and we need most employers, or all employers should, but most employers have an injury report on file that the member needs to fill out. Next slide, please. Okay, recent similar remands. Okay. Recently, we had a Group 4 member claiming PTSD following several traumatic incidents that he experienced. We had to remand it, though, because even though he could have provided incident reports of those incidents to try to support his application, he did not provide any incident reports. His superior wrote an affidavit, a month before his application was filed, saying these incidents happened. But again, they never provided those incidents, so we had to remand it. The second bullet point is a similar one. You need to provide the incident reports or an injury report for a Group 4 member, and they failed to do so. This third bullet point, the injury report said that the member was performing all police duties when he injured his knee. That was insufficient. We didn't know, we need to know the who, what, where, when of the injury and what the person was, performing. So we found that was not an official incident report. The board was able to make findings of fact, and they actually found a different document, an injury report that had been filed by a witness. Bottom line, he was found eligible for accidental disability. But at first, we had to remand it at first. We recently had, unfortunately, a school custodian. He filed his injury report 2 or 3 years after he claimed he hurt his shoulder shoveling snow, which is an injury we see a lot for custodians. But unfortunately, we had to remand it. And that's a kind of a no-brainer if it's, the injury report is filed more than 90 days after. It's very important. Get to all your, make sure all of your employers and your systems know that, the importance, or all your members of your systems, I should say, know that they need to fill out injury reports within 90 days of the injury. Okay, bona fide personnel actions. Often we see applications where the member claims to have sustained an emotional injury, such as, let's say, anxiety, depression, PTSD, due to the actions of a superior. Okay. Such injury does not constitute an emotional injury for the purposes of Section 7 if it arises from a bona fide personnel action, okay? Unless the actions of the superior rise to the level of intentional infliction of emotional distress, which is a really high bar. Now, examples of what constitute bona fide personnel actions could be a termination, a transfer, a reassignment, suspension, demotion, some sort of punishment. Superiors, just because they transfer you, doesn't mean that, well, it doesn't mean that they caused your PTSD, or maybe they did, but it's bona fide. It's just a work obligation that they can assign you to do, or they can suspend you or punish you, and you cannot, you're not eligible for a Section 7 benefit in such a scenario. Now, I mentioned that, and it could be, even if it's a bona fide personnel action, it could be eligible for a Section 7 if it was intentional infliction of emotional distress. Unfortunately, that's a really high bar. Okay. In order to demonstrate that your superior intended to inflict emotional distress on you, the board they have to prove that the conduct of the employer was extreme and outrageous beyond all possible bounds of decency and was utterly intolerable in a civilized community. That's a really high bar. Okay. So we have seen situations like this before. This next slide, please. Okay, this first matter, member claimed that he had PTSD following being informed that he would be terminated. He was found he was not entitled to accidental disability retirement because the termination was a bona fide personnel decision and did not, was not the intentional infliction of emotional distress. This matter is under appeal. We remanded it not only because it seemed to be a bona fide personnel matter, but also because in this fact pattern, it didn't seem that his injury principally arose from his termination. This gentleman had many other outside issues going on. The second bullet point, PTSD resulting from being transferred to a different job duty and shift. He was found he was not entitled to accidental disability because the employer was permitted to transfer him, and there was no evidence that the transfer was done with intolerable cruelty, or whatever the bar is for intentional infliction of emotional distress. The third one, which is a more recent one, is a member/dispatcher claimed that she had PTSD related to emergency calls that she received one day. Okay, one day was a really bad day, and she, developed PTSD because of it. Upon investigation, however, it was found that on that same day, she had been placed under investigation and put on administrative leave for failure to perform her job duties. Okay, so her being placed on administrative leave was a bona fide personnel action, and even if she developed PTSD, it was not. The calls that she claimed caused the PTSD really would not give rise to PTSD, and that's the board found that on remand. Okay. Next slide, please. Accommodated position. In this scenario, a member was a building custodian. He injured his shoulder and was given an accommodated position, which he worked at until 2018. In 2018, he applied for accidental disability for that shoulder injury he had sustained 6 years earlier. The question is, which position should the medical panel evaluate to determine whether he is disabled? Okay, should they use the custodian position or the accommodated position? And the answer in this scenario is the accommodated position. The SJC determined that an employer may assign an employee to an accommodated position to avoid the award of accidental disability, provided that the accommodated position's essential duties are similar in responsibility and purpose, and there is no loss of pay or other benefits. Recently, we saw a situation, and I think this is under appeal, that's why I did not put it on the slide. It was a firefighter who was injured in 2011. He was assigned to a permanently accommodated position in the investigative unit. Okay? He worked there without incident for 11 years. Okay? 8 days before his mandatory retirement, he applied for accidental disability and provided a job description for a firefighter. We had to remand it. Excuse me. We questioned the job description. Okay. The job description really should have been for the investigator, which was the role he had been performing for the last 11 years. And it didn't appear that he was disabled from performing that position. So we did have to, I mean, that's why job descriptions are so important. They provided the job description of the firefighter, but he was not performing the duties of the firefighter. You need to provide the description of the accommodated position in such a scenario. Undefined injury. These are rare. Section 7 talks about, must be a reason of a personal injury sustained or hazard undergone. Sometimes we see applications where we're really not sure how an injury happened or where it happened or what body part is injured. Oftentimes we just have to remand these with instructions for the board to just make findings of fact, telling us what happened here. Okay. I know this sounds very basic. If you apply for, accidental disability, you should be clear on what's disabled, but sometimes we get them where it is not clear. Next slide, please. We had a remand one recently, where the member says that he injured, he was seeking disability for an injury to his right shoulder. Oh, no, excuse me, I had that wrong. All the documentation said that he injured his right shoulder on a certain day at a training session. He was a firefighter and was doing some training. And he wrote out 2 injury reports, right shoulder. And his superior who was there said right shoulder. And he sought treatment on the right shoulder. Several years go by and he applies for disability, but it's for his left hand. There was no documentation supporting a left hand injury. It was only about the right shoulder. We had to remand it back to the board to make findings to coincide to make this work, basically. The board was unable to do so. So this gentleman is not eligible for accidental disability retirement because he did not sustain a left hand injury in the line of work. Another time we had a situation where the injury report said the member injured his left knee. But this was a very strange one. The report says he injured his left knee, but he was seeking disability for a back injury. He had a very confusing and conflicting description of both his injuries and of how it happened. Between the injury report, his application, the medical records, what he told the medical panel during his examinations, and what he told the board at a hearing, there were about 7 different stories. So we had to go back to the board and just ask them to please clarify this. We weren't looking to, if the man was hurt, by all means, he's eligible, but we just didn't know the story. So we had to remand it back to the board. Next slide, please. Okay, another class of cases that we have to remand sometimes involve what are called common movements. Okay. Now, in 1993, the Supreme Judicial Court decided the Adams case. Okay, that was a case where a member claimed that the constant standing, sitting, bending, and walking that she was required to do as a teacher caused her back pain that left her permanently disabled from performing her job duties. The SJC held that the petitioner was not entitled to accidental disability for such common wear and tear injuries. And they held that job duties involving common movements done frequently by many humans, both in and out of work, will not be sufficient to establish an entitlement to accidental disability retirement benefits. So this is the wear and tear common movements kind of case. And we have seen a few, and I have a few on the next slide. the case, there was a security guard at one of the universities. He was found not to be entitled to accidental disability for a lower back injury that he alleged was caused by having to wear a heavy belt and gear while walking his rounds. He claimed that the belt weighed close to 30 pounds and that it weighed him down. But that job duty involved a common movement, which was walking, which was frequent to many occupations, both in and out of work. So he was not eligible. The second one is a similar case. It was a corrections officer who developed bone spurs that he claimed was because of wearing heavy gear and walking and climbing up the stairs at the prison. This actually went on appeal all the way to Crabb, and Crabb found that those duties are common movements frequent to many in and out of work, and he was denied. The next bullet point is a sales representative. I think she worked for the lottery. She claimed that she was disabled for a neck injury that she sustained by her constant having to cradle the phone to talk to people on the phone. That was found to be a common movement, talking on the phone and craning your neck to talk on the phone. Common to many occupations, common to just life in general. She was found not eligible. A recent one that we came across that we had to remand was a van driver. A van driver for wheelchair accessible. A wheelchair accessible van driver was found not entitled to accidental disability for arm injuries that she claimed to have incurred by repetitive driving and pushing of wheelchairs. That was found to be a very common activity in and out of occupations, so found not eligible. And another recent one we had, it was a police officer who claimed that she had injured her back and could no longer work, and that the injury was caused by sitting in her police cruiser, and having to turn to use her laptop while in the cruiser. That was found to be a normal, common movement, common to just about everything in life, and unfortunately, she was found not eligible for accidental disability. Next slide, please. Presumptions. Patrice already talked about the presumptions in wonderful detail, so I won't go through it anymore. There's Section 94 is the heart law, 94A, the lung law, 94B, the cancer law. It's under most situations, if you have any of those afflictions, they're found to be presumed in the line of duty. However, there are exceptions. Next slide, please. The presumption can be overcome. Okay. It can be overcome if the member has a congenital heart or lung condition. Okay. If it's found to be congenital, then it cannot be presumed to have been caused in the line of duty because it's known that it was congenital. Sometimes we have to remand if the member has not provided proof that he or she successfully passed a physical on entry into service or subsequently passed a physical exam that failed to reveal any evidence of the heart or lung condition. With relative frequency, have to remand for this reason when there's no pre-employment physical or a subsequent physical. Sometimes there are letters that accompany the applications from the chief saying things like, well, this member would have had to have had a physical and would not have been hired had they had any evidence of a heart or lung condition. That's not entirely true. We see many physicals, pre-employment physicals, that reveal evidence of heart conditions or lung conditions, and the person is hired. And unfortunately, that's a reason why we have to remand as well, because it's not presumed to have been caused in the line of duty if it existed before you started working. Sometimes we have to remand if the firefighter served in a position for less than 5 years and they claim the cancer presumption. On the flip side, sometimes we have to remand if a retired firefighter discovers their cancer more than 5 years after their retirement. And, we do have to do that occasionally. But next slide, please. Some recent ones, and these are more like generally written out, but because they happen so frequently. Heart law, we had to remand, lack of the pre-employment physical or subsequent. There are some exceptions for long-time employees who may not have been required to have a physical, but they're few and far between nowadays. And just about everyone gets a subsequent physical. So there really shouldn't be any reason that someone can't provide that documentation. But we do take it on a case-by-case basis if it is a long-time employee who may not have been required to get a physical. Member was not entitled to the heart law because he was diagnosed with congenital heart condition. Again, we do see that. Aortic stenosis is a congenital condition, and we do see that come up under the heart law applications. Sometimes we see when someone retires just for superannuation, and then they subsequently, claim that they developed a heart condition after retirement. You need to be incapacitated from performing your duties while still a member in service. So we've had to remand for that reason. Again, a pre-employment physical showing evidence of a heart condition or a lung condition. Those are usually overcome the presumption. Cancer, we've had many of these. His cancer was not discovered within 5 years of his retirement. Now, it says discovered. It does not say diagnosed. So there does not have to be a formal diagnosis. So this one that I'm talking about, there was a medical record where the firefighter within the 5 years had gone for a checkup, and there was evidence of elevated PSA levels. When we remanded it back to the board, we suggested to the board that they consult the member's doctor, or we could refer a doctor, to determine whether those elevated PSA levels indicated the presence of cancerous cells. And then would that be a discovery of cancer? So we do try to help out in situations, like I said, when we send our remand letters, and give the boards, direction or suggestions on what they can do. The last bullet point here, it was a firefighter who claimed that he was eligible for the lung law because he contracted COVID, and it damaged his lungs to such a point he could not work. Unfortunately, the lung law requires that the lung issue was caused by the inhalation of noxious fumes or poisonous gases. The COVID virus is neither of those things. It's an airborne virus. However, we advised that perhaps there was a way that the firefighter could file an application under Section 7, saying that, the evidence overwhelmingly showed that I contracted COVID while on the job. Like I went out to an emergency call, and the person had COVID, and I had to rush them to the hospital, and I was diagnosed with COVID the next day, something like that. COVID being an airborne virus, very difficult to prove where you got it from. But fact specific. If the evidence shows and the facts show that it's, this isn't the standard, but more likely than not, it may be enough to salvage an application via Section 7. COVID is tricky. COVID is tricky with everything. I honestly, we don't see as many COVIDs as I thought. I thought we would. And, thankfully, you don't care much about COVID at all. So hopefully we're past that entirely. But so those are some recent ones we had. Next slide, please. Okay, Section 9. I mentioned that quickly earlier. This is accidental death benefits. Now, For accidental death benefits, it's very similar, the standard to accidental disability. Okay, here though, the beneficiary is entitled to a benefit for a member or retiree who dies, quote, as the natural and proximate result of a personal injury sustained or a hazard undergone as a result of and while in the performance of their duties. Okay, now most frequently, the Section 9 accidental death benefits applications that come in for a member who retired for accidental retirement under one of the presumptions, and then they die from that same illness. So for example, they go out under the heart law and then they pass away from a heart attack. That most frequently what we see. Now, the remands most often concern the question of whether the death was the natural and proximate result of the reason why they went out on disability in the first place. Next slide, please. Okay, we have had some recent remands. This is a common one. A member retired under the heart law for hypertension, but then the death certificate states that the member died from leukemia or from some other cause. The second bullet point too, it's kind of the opposite. They went out under the lung law, but they died from a heart attack. In both of these situations, what we normally do as well is we recommend to the board that it consult the treating physicians for the members and specifically ask the doctor whether the death was the natural and proximate result of the condition from which they retired. Now, oftentimes the doctors are able to say, his weakened heart condition that he retired for weakened his body so much that he could not fight, the other thing. He had the diabetes or something like that. If the doctors can say it was the natural and proximate result of, what they retired from, they're doctors. We don't overrule their judgment on medical care issues. Sometimes doctors can't do that though. They can't tie it together. They just, he died for something different. And, that's just the way it is, This third bullet, this is a little different. We recently had one, we had a remand because a son applied for a benefit for his father who passed away. Now, the statute, section 9(2)A, provides a benefit to a spouse, but if there is not a spouse, to a child under the age of 18 or 22 if a full-time student, or who is mentally or physically incapacitated via section 9(2)B. So you start at A for the spouse, then you go for B for the child, okay? Unfortunately, the son that applied here was in his 40s. He was not a viable candidate for a section 9 benefit under the statute. Now, the next bullet point, this was a similar one we had too. The statute provides that, okay, if there's no spouse and there's no child, okay, we go to 9(2)C. And 9(2)C provides that if there's not an eligible spouse or child, the benefit shall be paid to the, quote, surviving, totally dependent father or mother, or both, of such member. Here we had a situation where a relatively young woman passed away, and her father applied for the section 9. It looks like he, based on the documents we were given, it looked like he, was helped out by her. It did not seem that he was totally dependent upon his deceased daughter, however. And we went to the board and we asked them to make findings of fact. And I'm 99% sure that the board was able to make findings where they found that the father was in fact totally dependent upon his deceased daughter. And so he was able to get the benefit. Now, it goes, I'm sorry. Oh, in doing this, I'm sorry, could you go back one? In doing the research for this one, I was like, oh, 9(2)A, 9(2)B, 9(2)C. Well, 9(2)C even goes a little further, okay? And it says, okay, if there's no totally dependent parent, who does it go to? And the statute says, then it goes to any totally dependent, unmarried, or widowed sister of such member with whom he was living at the time of his death. So long as such beneficiary or beneficiaries survive, do not marry or remarry, and are unable to support themselves. That's just oddly specific. That seems like sometimes you come across statutes that are written with one person in mind. And this seems to be one of those situations. Thankfully, we didn't have to get there. The father was found to be totally dependent. Thank you. Next slide. Everyone's favorite slide, the conclusion slide. As I leave you, I just want to let you know that PERAC approves the vast majority of the applications it reviews. Each application is reviewed by 2 attorneys. And as I said, some of the reasons why we remand an application may be resolved, and in fact are resolved by the board doing findings of fact. And we are happy to approve if it meets the legal requirements. One more thing. I believe at the conclusion of this, a survey will pop up. We ask that you take a few moments and complete the survey. Your feedback will be very helpful to us in helping guide us on what you liked, what you didn't like, and what we can do better. And we're happy to have anything you have to say. And with that, I think we're going to go to any questions that may have been asked, and I'll pass it on to Natasha.
Yes, we have quite a few questions in the Q&A, so I'll read them off, and either you or Patrice can respond. The first one, the involuntary requires the employer to send an involuntary notice certified mail to the member. What if the member refuses to sign the certified letter? Does that impact the application?
Whenever there are situations, and we deal with it with some other matters as well, but whenever there are situations like that where someone just refuses, we usually advise the board to paper the file, meaning, just document everything that you've done, all the attempts that have been made. If there ever is a question, a court can look at it and say, like, well, the board did everything they possibly could have done here. Just because somebody, refuses to accept a certified letter, doesn't mean that they should be entitled to continue working. So try to hand deliver it, get affidavits from people who tried to hand deliver it. If any way you can try to get it to the person, just document it. Because if they ever try to fight you on it and say, hey, no, you can't, involuntarily retire. I don't see if this goes on appeal to, well, if PERAC sees it, or DALA or CRAB, they're not going to find for the person who just kept trying to avoid, receiving the mail. But document it and you should be good.
Great, thank you. Is there an exception to the lung disability retirement?
An exception to it? Well, I mean, if there's a congenital condition, that would be an exception. If there's a pre-existing condition, there can be, if there's evidence of, let's say, a smoking history, or evidence of, exposure to harmful chemicals while in the military, let's say, something like that. So there can be exceptions. It's not I can't say what it would be, but there's evidence, that it came from a different place rather than the job. That can be used as an exception to prevent someone from getting the presumption.
Okay.
One thing.
The individual, the individual who asked that question said they asked because of corrections officers who have worked in old buildings that are asbestos riddled.
I mean, did they? Well, you may not know, Natasha, but I mean, were they old buildings that were public buildings? I mean, we do see that it may not be a presumption type case, but you could apply under Section 7 as a hazard undergone. We've seen non-group 4 people that get it for working in sick buildings and having, toxic mold exposure that has caused them to be unable to work. So if it's not a lung presumption type issue, it may be a Section 7 issue for a hazard undergone.
Thank you. It's difficult or challenging to get 3 doctors at one evaluation. Why doesn't PERAC mandate 3 separate panels? This may move the process along. Just a suggestion. So I don't know if that's a question and just a
Well, the statute
Yes.
provides that you have the option, the member has the option of choosing a panel of 3 together or 3 separate ones. With COVID, we had to do separate ones. We are back trying to get the joint panels. Again, the joint panels are allowed. They were prohibited by law during COVID, basically. But we are able to do them. People seem slow to want to do the joint panels. So we don't schedule them as much anymore. But I do agree, it is hard to get the doctors together. But I will say, some doctors that we have, they want to do the joint ones. So they're more willing to accommodate their schedule. If they do a joint panel, only one of the doctors has to write a report. The other 2 just have to tell them, hey, I agree. It's, yes, 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 and they also, if there's 3 of them, they can sometimes see several applicants on the same day. So I just think it's a matter of, with COVID, everyone getting back up to speed, and having the space available for all the doctors. Sometimes with the joint panel, there's not enough space because you need obviously the applicant, you need the 3 doctors, but then they're allowed, as Patrice pointed out, they're allowed to bring their attorney, they're allowed to bring another doctor, they're allowed to bring a supportive family member. So there could be numerous people in the room, and there are space restrictions, but they're allowed to go with, if they want separate or they want joint, and we're trying to accommodate the best we can.
Okay, thank you. The 30-day remand, is that 30 business days or 30 calendar days?
That is 30 calendar days.
Thank you. Is there a local option for 15 years, and how does that work?
I think it is a local option, and I'd have to look at the statute. But I know it's not an incredibly arduous process. Several years ago, there were 4 boards that had the 15 years. And Patrick Charles gave a presentation where he noted that there were 4, and he jokingly said, we want to shame those 4 into getting it down to 10 years. And within a month or 2, one of those boards changed it to 10 years. I think it is via local option. I don't have the statute handy. But speaking of Patrick Charles, what I recommend is email Patrick Charles and ask him what the process is. He'd be happy to help you.
I'm sure he will. Next question. Do these members whose claims are not approved, especially I'm thinking of the bathroom cases or those who are injured on site, ever successfully bring litigation due to the physical safety issues, i.e. slipping and falling on a wet floor, for example, after they are denied for this specific benefit?
Short answer for me is I don't know. We deal with the retirement aspect of it. Whether they want to sue their employer in a court of law for dangerous conditions, or take an OSHA complaint or an MCAD complaint, we don't generally get involved with that, but I'm sure that things like that happen.
On the disability application, it says the injured member. Understand that giving false or incomplete information may subject me to civil and criminal penalties. Has this ever been enforced or implemented?
Not that I'm aware of. Having said that, I could just not be aware of it. It could have happened, but I'm not aware.
Okay, thank you. If an employee is asked to do something outside of their job description and is injured, how would this affect an application? I think you answered that.
That's a tough question. It really is. I'm the kind of guy who, I'm an all hands on deck. Something needs to get done. Let's do it. Okay. But technically, if you're injured while doing something your boss tells you to do that you shouldn't be doing, you may not be eligible. I do remember a case, actually, that Section 7 has a line in it about you not being eligible if the injury is the result of your willful misconduct. I remember a scenario where I believe it was a dump truck operator, power, heavy machinery operator, gentlemen. The truck broke down. His boss said, okay, I'm going to get the payloader and we'll attach some chains and I'll pull you. Okay. You sit in the driver's seat and you steer. Okay. And this was during a snowstorm. And so the men did that, lost control, got into an accident. I think he slammed into the payloader actually, and sustained injuries. And he said, hey, the boss told me to do this. And it went up through Dala and maybe even Crab, and they found that, you know, regardless of your boss telling you to do that, you shouldn't have done it, and that was willful misconduct. So that's, again, some of these cases I hate. I hate, you know, but that was willful misconduct, so it could happen.
Thank you. Next question. If an injury occurred and there are witnesses, according to the injury reports, why doesn't the PERAC disability application require witness statements? It may minimize the amount of applications the boards receive.
Well, we don't require it because the statute doesn't require witness statements. If there's anything that would assist PERAC in its review, being witness statements, we would highly encourage, they should be included in the application. You know, anything that, you know, assists the board in making its decision should be included in the application. And if there are witness statements, they should be included. And we review witness statements all the time when they're included in the applications. But yeah, it's not on our form because the statute doesn't say you need a witness statement.
Thank you. Can the board choose to deny a notice of injury request that is filed if the injury that occurred did not happen within the performance of their duties? Typically, our board accepts the notices of injury, but curious if they can deny the notice. If the notice of injury filed is denied by the board, does it remain with the member's file?
Well, I don't think it should be removed from their file. You know, they're claiming it, the board's just denying that it happened. But the board is free to, you know, look at all the facts and say, like, this injury did not happen, and we deny you a medical panel. That's the board's obligation. They can most definitely do that. Perhaps I didn't understand the question entirely, though, and I apologize. If that person wants to email me directly, actually, if anyone wants to email me directly for any questions, you know, please do. But if that person wants to, you know, I'll do my best to try to answer it a little better. Sorry.
Thank you. Can a cop who is doing overtime or a detail get injured, get approved for accidental disability if the job was not mandated or required? If detail is not his essential duties, how can a cop get approved for an accidental disability?
Detail work is a carved out exception that the courts have made. So a police officer who's injured while working a detail, even though it's voluntary, is covered by accidental disability retirement.
A question regarding the vest decision in regards to timing. Hasn't the vest decision in regards to timing been overturned?
Vest has not been overturned. There was a recent case where it was determined that PERAC's interpretation of vest was incorrect, but the vest decision itself has not been overturned. I did not touch on I did mention vest just for the sake of its case, because it is still good law. But whether or not someone needs to be disabled on their last day of work is, I would say, an issue in flux. And we're you know, working on addressing that to the boards in the best way we can.
Should we be requesting medical records beyond 5 years for injuries related to the claimed disability up front? For instance, re-aggravation or presumption, absence of pre-employment physical. Is there a regulation or statute that states how long providers have to provide medical records to the board? It may be difficult to obtain records from say, psychiatrists or psychologists compared to providers in other medical fields?
Yeah, obtaining medical records is always tricky and difficult, and we know that with COVID, record keeping and record providing, was definitely not a priority at a lot of the medical environments. Having said that, I believe the PERAC regulation states that the record should be 5 years for anything, basically, but it should be all of the records related to what they're claiming the injury on. I'd have to go look at our regs again, to see exactly how it states it, but I do believe it is in our regulations, which is 840 CMR 10.0.
Okay, thank you. Is there a time limit from superannuation to filing for an accidental disability?
You may oftentimes we see people they apply for accidental and superannuation at the same time because they just know the superannuation will, happen quicker. They obviously don't have to go through medical examinations. I don't know if there's a time period other than the 5 years for the cancer look back. I don't know if that's what they were talking about. But we do see situations where someone, I saw one recently that it was, they had been retired for superannuation for several years. And then the approval of a disability came on my desk. Well, it turned out that had been up on appeal for years. So just things like that happen. They delay, just takes a while. So I don't think there's any time limit. But again, if I'm misunderstanding the question, I apologize. Please email me and maybe we could, parse through it a little better.
If a member smokes and then gets lung or other cancer, how should that impact the board decision?
Well, the board should make if the panelists do not, if the medical panelists do not address the smoking issue, then the board should definitely seek clarification and provide the panelists with any information it has about a smoking history of that person and ask the panelists to opine on whether such smoking would have had an impact on the eventual lung condition.
Can you review the catch-all phrase to add to office job descriptions that would cover injuries due to things like changing the water cooler? And I did have a recommendation to get a bottom loading water cooler here in the questions as well.
Yeah, I don't know the exact, there's been no case that has gone up where someone has been injured moving the water cooler and they can show a job description that says what their job entails that permits them to get accidental disability. I'm just giving you what I believe could be sufficient. I mean, it's better than nothing. And that would be something along the lines of, must perform any task that assists the employer and or employees with day-to-day operations. That sounds good to me. But again, no court of law has ever said that is good enough. Okay. If you can word it better than me, if you want to put in change the water cooler, that's probably the best answer. If you want to be that specific about the water cooler, maybe put that in the last line of everybody's job description or certain people's job descriptions. I'd have no problem with that. Again, personally, anyone who changes the water cooler is good in my book.
Mine too. If an involuntary application is received and the member then files a voluntary app, but does not submit all required documents, would the voluntary be withdrawn and the involuntary be pursued?
If they file the voluntary, but it's missing documents, I think the board should let the member know, hey, your application is not complete. You need to get us these documents. In the meantime, we're going to pursue the involuntary.
Okay, thank you. If a board seeks clarification or sends anything to a medical panel during the ADR process, are they required to copy the member and or his or her attorney?
Yes, I believe they are.
How is it that 3 boards can establish a 15-year criteria for service time in the system?
Well, the statute says it's 15 years. You have to proactively go in and then lower it to 10 years by the local option. So the statute is what mandates it, but just 101 out of 104 have proactively gone and changed it to 10 years.
Thank you. This one's related to travel. If an employee is driving a personal vehicle from one municipal work location directly to another, is that employee covered?
Yes.
So for example, going from a firehouse to a different firehouse, okay. A number of boards require that the member obtain and submit medical records, and other boards request the records using the release in the application. Does PERAC have a preferred method?
I believe the release is the requirement. And well, regardless, that is what we would prefer. We want the release. There's some concern if you put it in the hands of the member that they maybe pick and choose what medical records they want to include with their application. The release is what should be used so that, the board can assure that it has everything.
Thank you. Okay, we have about 15 more questions to answer, or 14 more questions to answer. I just want to let everyone know that we are coming up on noon, but we're going to stay just a few minutes longer just to answer these questions, if that's all right with you, Ken.
Sure.
But anyone who has to leave now, feel free to do so. You'll still get your credits for leaving, even though you leave early. But all right, so we will continue. I just wanted to make that note. Can direction to complete a task not in a job description from a direct supervisor or manager be considered for approval? I think you answered that.
Yeah, that's kind of goes for the willful misconduct, possibly. Without a factual scenario, I can't say. I mean, if it's a legitimate, directive to somebody, then it could qualify, even though it's not in the job description. But if, the boss tells you to do something that is completely irresponsible, I think the law would be like, you have the responsibility to refuse to do that.
Many members who are approved for disability often receive an initial payment that is retroactive back several months or even years. If the member had other earnings during the period covered by the retro payment, do the 91A earnings limitations apply retroactively as well?
Getting a bit off topic here, but yeah. But yes, they do. So while that was pending, while the retroactive, like if it was at dollar or anything like that, and then they get a huge retro. But during that time, they'd been working. 91A applies. Okay, they may owe the board a refund of that amount. 91A does apply. And Travers, Travers. There were a couple of cases with Travers, but the most recent one, I think, upheld that he owes 91A for those years while it was pending.
Who does the written injury have to be filed with in the 90 days?
It's supposed to be filed with the retirement board, according to the statute. Realistically, not every employer thinks, oh, I better make sure that the retirement board gets this. So as long as it's on file with the employer, and then the person years later or months later applies for accidental disability, and then at that point the employer provides it to the board, that's fine. That's fine. You can't punish the member for, not knowing that he should have insisted that the employer provide the injury report to the retirement board.
For firefighters filing an ADR under the cancer law within the 5 years after initial retirement, has PERAC considered coming up with a condensed application rather than the same 18-page ADR application?
We have not considered it. This was just brought to my attention via an email just a few days ago, so I have an inclination of who's asking this question. But Patrice and I did talk about it, and I doubt that we will come up with another form, but perhaps there's a way that we can say, like, for those firefighters that are applying for, subsequently, within the 5 years after retirement, injury or illness, for those people, maybe you can skip to question 18 or, question 7. Maybe there's a chunk of questions that we can authorize them to skip, but we have not gone any further than just that conversation. And again, I only just found out about this issue or, request 2 days ago. So, but it's something we'll consider.
Okay, thank you. A firefighter has been out on accidental disability for many years. Now they want to come back to work. Is that a simple process? If they get approved to come back to work, they get their years of service while out on disability. How long do they have to wait to retire?
They could retire the next day. I mean, the first part of that is it's a long process. You have to go through the return to service process. You have to go through the CME process, then the return to service process. With return to service, all 3 doctors must be unanimous that you can return to work. Then there must be an opening of the job. If you've been out for a certain amount of time, you might have to go to the academy again. But let's say you go through all those hoops and you do everything that's required of you, and then you come back, you can work a day and then you can retire the next day and you get creditable service for all those years you were out on retirement. It's a horrible loophole, if you ask me.
Firefighters and police officers do PT, I'm assuming PT means part-time, work out at their respective academies. If either are hurt while doing PT, working out during their shift, or like some workout at work prior to or after shift ends, would they be covered if injured and forced to apply for accidental disability? So maybe PT is physical therapy.
Yeah, I'm thinking it's physical therapy. It depends. I know state troopers, it's, in their contracts that they need to work out a certain amount of time. And we've seen where they've sustained injuries while working out. The regular rank and file, well, not rank and file, but non-state troopers who injure themselves while working out, generally, I would say they are not covered. Perhaps there's some sort of job description that mandates them having to do it. I couldn't say on a sweeping basis, but on the whole, I would say unless there's something crazy in a collective bargaining agreement or something, that they would not be covered for injuries while working out. The reason is it's good for everyone to work out. It really is. Would it help, more to be a police officer who's strong than, like the clerk behind the desk? Of course, but everyone should be, and try to get in the best shape of their life. So that just seems common to all or very many occupations.
Do you have an update on the Hollip case, and how will this affect the Vest case?
That is the one we're working on. I mentioned earlier with Vest, it did not overturn Vest, but it kind of reinterpreted how PERAC sees the conclusion of Vest. So we are working on that. We don't have an update at this time.
If a member takes a refund, can they later apply for a disability allowance?
Disability remands, huh? I'm sorry, could you repeat that again?
If they take a refund, can they later come back and apply for disability?
So they're no longer a member in service if they took a refund. They're not,
Right.
and they'd be applying for, no, they can't apply. You need to be they cannot apply for accidental disability unless I'm missing something, which I may be.
Trying to
So
trip you up, Ken.
I-
Making sure you're paying attention.
it's certainly not a question about remands.
Let's see. I have just a couple more. One is a request if we can increase the file size for uploads into Prosper from the current limit, because it's a lot of work to break up large volumes. So we'll bring that up with our IT staff. Chapter 697, Section 117 of the Acts of 1987 says no person who smokes tobacco products shall be eligible for appointment as a police officer or firefighter from any civil service list after the effective date of this act, and no person appointed shall continue in such office or position if such person thereafter smokes any tobacco. When I read medicals, it says stopped smoking years ago. Some other medicals would say never smoked. Others say would say quit before becoming a firefighter. Does the medical panel only read the medicals, or do the doctors actually require some type of physical testing? And could the medical doctors require some type of test to determine if the person still smokes?
They can't require any invasive testing. They can recommend, that the board may want to seek, to have the member examined for X, Y, or Z. But I mean, I have a feeling the person who asked that question is probably the one who asked me the earlier question about smoking. And then they came out with a statute from the 80s.
And let's see, the final question, but I will read out loud one comment before going to that question. And the comment is, this was an excellent presentation by the presenters. So kudos to both of you. So the final question is, has there been any examples of hybrid remote work affecting whether you are considered going to, from, or at work?
Thankfully, I have not seen many. I did fear we would see a lot of hybrid, issues with accidental disabilities. Nothing comes to mind that I've seen in terms of the traveling to or from work. Yeah, I honestly, I cannot think of anything off the top of my head. Now, I'm just thankful that it hasn't been as big a deal as I feared it was going to be.
All right. Well, thank you, Ken, for answering all those questions. I think we may have hit a record with number of questions during one presentation. So thank you all for your engagement. We didn't even need poll questions this time around. All right, I will turn it over to you guys. Thank you.
I just wanted to comment. Thank you, everybody, for hanging in. Thank you for all your questions. Thank you, Ken and Patrice. Ken, great job on the hot seat there. As you can see, we are here to help. We're here to collaborate. We're all in this together. We want to work together. Certainly, please do not hesitate to reach out to us at any time with any questions. No question's a bad question. God knows I'm asking everybody under the sun anything. So no shame in asking questions. Come to our future trainings, get to Macris, network with us, network with your colleagues at other boards, and have people you can lean on for help. And then just another quick shout out while this was going on. I got notification that a board snuffed out a fraud attempt. Somebody's trying to do the direct deposit change scam, and the board was on alert, made a phone call to verify it. turned out to be a fake. So kudos to all of you for doing that, and kudos for letting us know so that we can stay on top of these things and try to inform people what's going on and come up with some recommendations to try to help them from proliferating. So thanks to everybody for your participation today, and thanks to Ken and Patrice. And I don't know if there's anything else that we need to add, Natasha or Ken.
I'm good. I've talked enough.
No, that covers it, Bill. Thank you so much. Just a reminder that this presentation was recorded. We will post it up to the website in a few weeks. And if you need the handout, you can download it from the chat. Do that now. Otherwise, you'll have to wait until we post it fully to the website. And any board members, you will automatically get your credits. So no need to reach out to Rose. She'll get the attendee list and we'll update your records. So thank you, everyone. Have a great afternoon. Thanks for hanging on with us.
Thank you.
Have a great day.